get on the road. I'm Amy Funderburk. I'm the Clerk of Court for the Supreme Court of North Carolina. I'm also a two-time ECU graduate. Do I have any other ECU grads? Okay. Now, the first session this morning did right by me. So you have to be as good as they were. Purple. No. Purple. No. Purple. No. All right. I'm back home. So before we get started, I want to thank you for coming, first of all, but I also want to tell you a little bit about the court system in North Carolina. The court system is established to protect the rights of the parties in North Carolina and to make sure that disputes are resolved appropriately. Now, courts hear two categories of cases, civil and criminal. First up this morning, we heard a civil case, dealt with family law. You are going to hear a criminal case. Criminal cases are instituted when someone is accused of a crime, and the prosecutor believes that they can prove beyond a reasonable doubt that that particular person committed that particular crime. Beyond a reasonable doubt. Defense attorneys will present any evidence they have that they believe casts doubt on the guilt of the defendant, and they will present any legal arguments they believe that show the state made mistakes or presented inaccurate legal information. Under both the state constitution and the U.S. Constitution, criminal defendants are generally given a right to a jury trial. Now, juries do not decide issues of law. They decide issues of fact, meaning they hear the evidence, they hear the testimony, they weigh it, and they make a determination as to what they think actually happened in the case. It's up to the judges generally to determine what the issues of law are. Jury trials end with a verdict. They find the defendant either guilty or not guilty. If the defendant is found not guilty, then they're free to go. If the defendant is found guilty, then some type of punishment is imposed, and that could be imprisonment, that could be probation, it could be a fine. Now, civil cases are what most folks think of as lawsuits. These cases involve one party suing another party. Usually they involve private parties, but they can also involve the state or federal government suing or being sued. The suing party is called the plaintiff. The party who is getting sued is called the defendant. Usually the plaintiff is going to want money from the defendant in a lawsuit, but they could be asking the court to force the defendant to do something or to not do something. They could be asking the court to order that the defendant follow the terms of a contract or set a property boundary. Unlike in a criminal case, the losing party in a civil case is not subject to imprisonment. The civil cases will end in a judgment, and the judgment establishes what, if anything, the defendant owes to the plaintiff. Judgment in a civil case can also impose an injunction, which orders the defendant again to do or not do something. After a trial, whether it's a civil trial or a criminal trial, is finished, the losing party can appeal to a higher court. There are two levels of appellate court in North Carolina, the Court of Appeals and the Supreme Court, who you're going to have the chance to see today. Except in very serious matters, such as when the state imposes the death penalty, the first level of appeal is to the Court of Appeals of North Carolina. The Court of Appeals hears cases in a panel of 3 judges. They decide those cases by majority vote. A losing party is only entitled to review by the Supreme Court of North Carolina if the Court of Appeals judges disagreed on an issue in the case. Otherwise, the party that did not prevail has the option of asking or petitioning the Supreme Court to take their case, and then the Supreme Court will make a decision as to whether or not they will review the case and bring it forward before them. Now, the appellate courts don't hold trials. Instead, They review what happened in the trial court to determine if all of the proper procedures were followed and to ensure that no legal errors occurred. The lawyers will conduct, as you'll see today, arguments in front of the appellate courts, laying out the issues that the court must decide and describing why they believe their client should win the case. Appellate courts, as opposed to juries, specialize in determining questions of law. They leave the fact-finding generally to the trial courts and instead focus on the law itself, whether that's interpretation of a provision of the state constitution or a provision of state statute. Right. Our Supreme Court also decides cases by majority vote. They sit in a panel of 7. You'll see all 7 of our justices today. Now, if a party comes to the Supreme Court of North Carolina, the decision of the Supreme Court is final as to all issues of state law. If there's an issue of federal law, the parties can appeal one more time to the Supreme Court of the United States of America. Today, you're going to have an opportunity to observe a criminal case that has been appealed to the Supreme Court of North Carolina. We're fortunate to have 2 attorneys that argue in front of the court quite a bit. Normally, we sit in Raleigh, but in celebration of the 200th anniversary of the Supreme Court of North Carolina, we're traveling throughout the state. Yesterday, we were in Halifax County. Tomorrow, we will be in New Bern. And through 2020, we will be traveling throughout the state as well as holding court in Raleigh. Please come see us in Raleigh as well. At this time, I'd like to take an opportunity to introduce Justice Irvin, who is one of our associate justices on the Supreme Court of North Carolina, and he's going to discuss a little bit about his road to the Supreme Court.
Okay. All right, good morning. I've was told I was supposed to talk about my road to the Supreme Court. The interesting thing about that question is I'm the only member of the court that doesn't live in Raleigh. And so the technical answer to that question for me is I-40. Because I get up on some morning every week and drive back to Raleigh to go to the court. So I have a literal answer to that question. I'm glad to see all the students here. One of the things that we try to do with these out-of-court sessions is to use them as opportunities for civics education. A number of members of the court have spoken to school groups down here in Pitt County. We're willing to do more if anybody would like us to do that. If you can see somebody after the session, if you're interested, we'll be happy to do that. My route to the court was fairly conventional. I'm a 4th-generation lawyer. Apparently, we can't do anything else but practice law in my family. And so I had a pretty typical route. I'm a product of the Burke County Public School System. I went to Davidson College as an undergrad. The only way I can pander to the East Carolina folks among you is that we appreciate you sending us Bob McKillock as our basketball coach. He's been there for 30-some-odd years and is an ECU graduate. Graduated from Harvard Law School in 1981 and then practiced law in Morganton for almost 18 years. I did a general civil and criminal and administrative law practice. Essentially, we tried to do virtually everything that walked in the door except family law, which of course was exactly the area that the case that we just had was in. So didn't know much about that when we got started. In 1999, I was appointed by former Governor Hunt to a body called the Utilities Commission, which is it sort of looks like a court if you go to look at it, but it deals with the subject of utility rates and service quality. My brother, who is also a judge, says it's like watching paint dry, but I thought it was pretty interesting. While I was there, I had a chance to be the chairman of the Electricity Committee of the National Utility Commissioners Association, testified in front of Congress twice, and also had a chance to decide some really pretty interesting and complicated kinds of cases. In 2008, I decided to kind of get back to my roots and run for a seat on the Court of Appeals. As I'm sure you know, these are elective positions. And so I ran and spent a fun year traveling all around the state, including several trips to Pitt County, campaigning to be elected to the Court of Appeals and was able to persuade the voters that they ought to elect me. So I began to serve on the Court of Appeals in 2008. In 2014, decided to run for the Supreme Court, was again elected, and have been serving on the court ever since. It's a great privilege for us to be here. We need to move along, so I'm going to stop talking. But thank you very much for all of your help in setting the session up.
Thank you. Thank you, Justice Ervin. We'll be getting started very shortly. I'd like to remind you at this time, if you have your cell phone with you, please turn it off now. And we will be starting very, very shortly. Thank you again for hosting us here in Pitt County.
Good morning. Once again, we want to thank everybody here in Pitt County for welcoming the Supreme Court of North Carolina to hold its special session here today in commemoration of our bicentennial anniversary. We are very, very grateful to Judge Blunt for all of his help and support, and everybody else, commissioners and everybody who was supportive of the full undertaking of revamping this beautiful courtroom to accommodate the Supreme Court. We are having a really wonderful time and are truly, truly grateful for you all allowing us to be here. I know there are lots of special guests here today, and we also welcome you all and appreciate the folks, the lawyers here who've traveled from Raleigh. The court will call the case of State versus Bowman. And Mr. Hyde.
May it please the court, my name is Joe Hyde. I represent the state in this matter. This case is before the court on the basis of the state's appeal from a divided panel of the Court of Appeals, and also because this court granted the state's petition for discretionary review of an additional issue, whether the trial court erred in restricting the scope of the defendant's cross-examination. I'd like to reserve 5 minutes of my time for rebuttal. The issue in this case is whether the trial court abused its discretion by sustaining the state's objection to several objections during the defendant's cross-examination of state's witness Lakenda Malachi, the only witness to the defendant shooting and killing the victim. The rule is that it is a violation of the Confrontation Clause to preclude a defendant from raising a witness's pending charges when the fact of those pending charges might show that the witness has some incentive to testify for the state. In the present case, the trial court allowed defense counsel to cross-examine the witness Malachi about her pending charges. The trial court allowed defense counsel to ask what she hoped to gain by testifying for the state. The trial court did not err, therefore, by restricting the defendant's cross-examination and sustaining the state's objection to other questions that were asked. My argument is divided into three parts. I'd like to spend a little bit of time talking about the rule and how that rule developed. And then I'm going to turn and I'd like to examine the actual cross-examination that was conducted here. And then finally, I'm going to speak about the Court of Appeals opinion and precisely how the Court of Appeals opinion misconstrued the rule and got this wrong. The general evidentiary rule is that pending charges are off limits. This court's precedent is a case called Williams. There's also a more recent case called Jones. And those cases reiterate the general evidentiary rule that a witness's pending charges are not a proper basis for a cross-examination. The reason for that is fairly obvious. Pending charges, an unproven accusation, doesn't demonstrate anything. So in the general evidentiary sense, the fact that a witness has pending charges, that's off limits for cross-examination. The Confrontation Clause of the Sixth Amendment provides a check on that general evidentiary rule. And the evidentiary rule has to yield to the constitutional principle, so that when a state's witness has charges pending against that witness, and it gives the state some leverage, I think what the U.S. Supreme Court case is Davis v. Alaska called a weapon to control the witness. When the state has some leverage, then it's a violation of the defendant's Confrontation Clause rights to preclude the defendant from examining, questioning the witness about those pending charges. It goes to the bias of the witness, an incentive to testify for the state. Now, a few cases from this court have examined that rule. The principal case construing the U.S. Supreme Court case is a case called Pravat. What happened in Pravat, very similar to what happened in Davis v. Alaska, is that the trial court precluded the defendant from cross-examining the state's witness about these pending charges. And this court looked at Davis v. Alaska and said, based on the Confrontation Clause, witness has a right to cross-examine the state's witness about these pending charges. So where the trial court absolutely foreclosed any examination into the pending charges, precluded the defendant from asking the witness about whether there was any incentive to testify for the state, this court found that to be reversible error.
But here it wasn't preclusion of questioning, it was more that there was a lack of effective questioning, or at least that's the concern here, isn't it?
Yes, Your Honor, it is. And that language about effective cross-examination comes from Davis v. Alaska. The rule from the U.S. Supreme Court is that a defendant is not allowed to cross-examination that is effective in every way, in every possible imaginable context. A defendant is entitled to an opportunity for effective cross-examination. And if we look at the language from Davis v. Alaska, the U.S. Supreme Court is very clear on what that means. To make such inquiry effective, I'm quoting from the U.S. Supreme Court in Davis v. Alaska, it's page 318. To make such inquiry effective, defense counsel should have been permitted to expose the jury to facts from which jurors could appropriately draw inferences related to the reliability of the witness. So the question is whether the defense counsel was permitted to elicit from the witness enough evidence to show that there were pending charges and that those pending charges might cause the witness to testify in a particular way.
Well, there has to be a difference between the opportunity for effective cross-examination and the fulfillment of effective cross-examination if, in fact, the trial court is erroneously sustaining objections, isn't it?
That's right, Your Honor. That's certainly true, but there does need to be sort of an awareness of the fact that cross-examination might be ineffective for other reasons than the fact that the trial court hasn't allowed inquiry in a particular field, hasn't allowed particular questions, or hasn't allowed cross-examination at all. And what I mean by that is there might be a situation where defense counsel simply stops asking questions. Defense counsel doesn't elicit certain information that is available for the defense counsel to inquire. And so the question is, whose responsibility is it that that evidence was not elicited?
Well, here we have discrete instances in which the trial court sustained the state's objections to certain questions following up on this topic. So How do we draw the line? At what point does it no longer become effective cross-examination?
Right, precisely. And for that answer, I would ask this court to look to its precedent in State v. Atkins. What we're dealing with here is specifically the question of whether defense counsel was allowed to elicit enough information to show that the witness had pending charges and that the state had some weapon to control the witness. So in answer to Your Honor's question about where that line is drawn, the answer would be whether the defendant was permitted to elicit that information, that there were pending charges, and that the witness perhaps had a plea agreement, had some reason to testify for the state. The language that was used in Atkins is the trial court allowed exactly the type of questioning mandated by Pravat.
But, counsel, isn't the difference in State v. Atkins that the cross-examination there was seeking a legal conclusion rather than evidence of potential bias, and that's why the objection in Atkins was proper?
That's correct. But the question is not so much whether the objection was proper or whether the sustaining of the objection was correct. The question is, it's a different question from an evidentiary ruling where we're wondering whether the trial court excluded certain evidence in error. The question here is whether cross-examination was restricted in such a way that the defendant was not permitted to put before the jury the fact that there were pending charges and the fact that the witness may or may not have a reason to testify for the state. And what happened in Atkins is the defendant was allowed to ask about these pending charges. What are you charged with in this case? Aiding and abetting murder. So you can't get the death penalty. Objection. So Your Honor is certainly correct. There was an objection to a legal conclusion that was sustained. What kind of promises has the state made you in exchange for your testimony? None. So regardless of the objection, the defendant in Atkins was permitted to elicit evidence from the witness that there were these pending charges and that there had been no promises made in exchange for the testimony. So regardless of the particular basis of the objection, whether the objection was correct or not, the line has to be drawn in whether that evidence, the Pravat-oriented evidence, is in front of the jury. Is the defendant in a position during closing argument on the basis of the evidence that is elicited to argue that this witness is testifying for the state because the state has a weapon to control the witness?
I'm sorry, can you talk about the difference between this purported weapon that the state might have over the witness versus a plea agreement?
Well, the plea agreement would be an example of that type
of the weapon.
Yes. It's any incentive that the witness would have to testify for the state. And obviously the prosecutor is going to want the witness to say, I haven't been promised anything, or I don't have a plea agreement. I'm testifying to this happened because it's the truth, because I'm a believer in the truth, because I want the truth to come to light. But it's comparable to a situation where the state is required to turn over incriminating evidence. The state is required to turn over to the defendant evidence of a plea negotiation or some agreement that the witness has made. All of that are various ways that the state can exert some influence on the witness. And because it goes to the witness's bias, because it goes to precisely why this witness is here and testifying in the way the witness is, the defendant is entitled to inquire into that information on cross-examination. But the particular issue here, it's not just cross-examination in general. It's not a free field to ask whatever questions you like. What we learned from Atkins is, has enough evidence been elicited to show that there are pending charges and that the witness does or does not have a reason to testify?
And so what we have here, at least as I read the record, and I'm always happy to be corrected as to my reading ability, is you have the illicit evidence that tends to suggest that you have charges pending in, I believe, Guilford County in this case. You then have a question that says something to the effect of what you hope to gain from this. The answer is justice for the victim. And then there's no willingness, apparently, on the part of the trial court to allow any follow-up to that question. There's at least two objections sustained after that. So what we've got here is, one, there's charges pending and the denial that I have any other than altruistic motives in being here. Why, assuming that's somewhere close to an accurate description of the record, if it's not, straighten me out, why is that enough with no follow-up?
The reason, well, first of all, the cross-examination is more extensive than that. First of all, the trial court had ruled that it was going to allow evidence of the pending charges, and almost three full pages of testimony dealing with those pending charges.
Out of the jury, out of the presence of the jury?
No, Your Honor, in the presence of the jury.
Okay.
Page 618, 619, and 620 are all evidence that was elicited before the jury. But ultimately, you're right. It was two questions, objections were sustained, and then defense counsel stopped asking questions. Now, whether the trial court would have allowed additional exploration of those topics, we don't know, because the defense counsel stopped asking questions when those two questions were objected to.
And there was no offer of proof, best I can see.
There was an extensive voir dire
After the objection.
after the
was
fact.
sustained.
That's correct. But that's why I say it's not so much a question of whether certain evidence was excluded in error. It's a question of whether the cross-examination was unconstitutionally restricted so as to preclude the defendant from examining whether the witness had pending charges and what the witness hoped to gain.
So in your view, is it, or in the state's view, is it enough to show, one, that the charges exist, and to ask a question that somebody might read as suggesting that you might be getting anything else, and that's all that's required?
That's not me, Your Honor. That's this court in State v. Atkins. The trial court allowed exactly the type of questioning mandated by Pravat. That's what happened here. The trial court allowed the type of question mandated by Pravat. And the fact that there were objections sustained doesn't diminish the fact that the defendant was permitted to put before the jury the fact that this witness had pending charges, and the fact that the question, so you don't think, what do you hope to gain out of testifying here for the state? And the witness answered, justice for the victim.
But didn't you cut it short in terms of that full question? Actually, it's what, if anything, do you hope to gain out of testifying here for the state with regard to those 5 pending
With regard to the charges.
To which the response was justice for Anthony Johnson.
Yes, Your Honor.
The defendant contends in his brief that that is non-responsive because it's not a direct response to what do you hope to gain from the 5 charges. It's what you hope to gain is justice for the victim. How do you respond to that being a non-responsive answer in terms of, again, going back to what would be effective cross-examination if this is arguably an evasive answer regarding the 5 pending charges?
It may be an evasive answer, Your Honor, but the state is not responsible for the evasion in that answer. The question under Pravat is whether the defendant was allowed to elicit enough information which the jury could infer that there was some influence from the state. So I would posit that I'm not even sure it was necessary that the defense attorney ask that particular question, what do you hope to gain? Because over the course of these 3 pages, defense counsel had elicited, pursuant to the trial court's ruling on the motion in limine and in voir dire, that it would permit the defendant to discuss the witness's pending charges. So you can see, just on the basis of this, making a very effective closing argument, right? Defense counsel gets up and says, you heard this witness on the stand testify she's got these pending charges. She knows what the possible sentence might be. The state has a weapon to control this witness, so that when she says, I asked her, what do you hope to gain? And she says, justice. The fact that that's an evasive answer, I think, could work in the defendant's favor. Imagine an attorney standing in front of the jury. Do you seriously expect, do you think it's reasonable that this witness saying, I want justice for the victim, isn't thinking in the back of her mind that I've got these charges pending and there's a very severe sentence that the state can control, can dismiss or pursue, and she wants you to believe that she's here for justice?
But does this court also have to look at the fact that in addition to what the state's obligation is, what the trial court's obligation is as well, is in terms of allowing the cross-examination of the witness in such a way that the trial court is not erroneously impairing effective cross-examination by sustaining these 2 subsequent questions?
I'm sorry, will you say that?
But in terms of the sustaining by the trial court of the 2 subsequent questions, doesn't this court also have an obligation to look at what the trial court did relative to whether or not there was error in sustaining those 2 subsequent questions to talk more about those 5 pending charges?
That's certainly the issue that's in front of this court, is whether that was error to sustain those 2 subsequent questions. But that error has to be contextualized in the sense of what the error is as presented by the defendant. And what he's complaining is not that the trial court erred by sustaining these objections in general, but that the trial court erred under Pravat by precluding him from eliciting from this witness that there were pending charges and that she hoped to gain something from them, that the state had some weapon to control the witness. And as you can see from the 3 pages discussing the pending charges up to that point, there was certainly enough evidence elicited here for the jury to make that inference, for defense counsel to make that argument. So you're right. I mean, the question is whether those sustained objections were some kind of erroneous restriction. There's no doubt that they precluded the witness from answering those questions that drew an objection. But the issue under Pravat, under Davis v. Alaska, is whether there was enough information elicited about the pending charges. And I think it's apparent from those 3 pages that there certainly was. There certainly was. That there were these pending charges, what the sentence was, who was prosecuting them, who the defense attorney was, what she hoped to gain from testifying for the state.
So how is this different from the situation in Pravat, where the court ordered a new trial because of the trial court's unwillingness to allow further cross-examination about a very similar kind of thing?
Right. So Pravat sort of mirrors Davis v. Alaska, that the trial court precluded any questions at all. The defense counsel was not permitted to put before the jury the fact that the witness had these pending charges. I think the situation in Pravat was another witness to a shooting, and the trial court precluded any question at all about the fact that that witness in Pravat had charges pending for forgery and uttering. So the defense counsel in Pravat did not have the ammunition that he had here to make the argument to the jury that the state had some weapon to control the witness. There was just a complete restriction on cross-examination. Unlike in this case, where you see from the motion in limine, from the voir dire, and from the questions that were actually asked, defense counsel was able to elicit that information.
Well, in Pravat, the court also said that the effect of any additional testimony about that was something for the jury to determine.
Right.
That principle would also apply here, wouldn't it? Any additional testimony that the witness would have given, the effect of that on her, how they evaluated her testimony would have been for the jury.
That's correct. That's true. But again, I would ask this court to look at Atkins. The trial court allowed exactly the type of questioning mandated by Pravat. And Atkins demonstrates that the fact that there is an objection that was sustained, the fact that there was a kind of restriction on the cross-examination, isn't conclusive for the inquiry under Davis v. Alaska and Pravat. The question is whether there was enough evidence elicited that would allow the jury to make that inference.
Well, it does look like a slightly different situation in Atkins, where the court specifically said that they were not allowing it because it was a question of law that they were seeking to elicit.
That's true. That was apparently the reason for sustaining the objection. But I'm not sure that matters so much, because the question is whether the defendant was allowed to elicit enough information to show that the witness had, that the state had some leverage over the witness. That's the basic question. We're not just talking about did the defendant have evidence he wanted to put on that he wasn't permitted to put on. It's did he get enough?
Well, I guess the difference that I'm wondering about is that for the witness to have answered about a question of law would have been not really for the witness to answer, and therefore not for the jury to evaluate.
Right.
Whereas additional testimony about their understanding of what was going on with their charges would be. And so I'm wondering why would be for the jury to evaluate.
The state's position here is that because you have that tension between the evidentiary rule that says no pending charges and the constitutional requirement, that the trial court was asked to make kind of a compromise. And that's what the trial court did. He said, I'm going to allow questioning, but I'm not going to allow extensive questioning. I'm going to allow this to go only so far. So I don't think it's necessary to go into exactly what the basis for the objection was, but I think what you have here is precisely what the trial court had forecast. And I would also point out, these 2 questions that drew an objection, you don't think you're going to get anything out of it. Are you aware of any other considerations you might have? I'm not sure what maybe he's thinking contract, consideration for an exchange for the, and then he stops asking questions. There were other questions that were asked on voir dire that explored these issues a little further. If that evidence wasn't elicited here, that wasn't the result of the trial court's ruling. That's because the defense counsel stopped asking.
Well, wasn't that not the first time that the judge had sustained the objection by the state? correct?
There were two objections that were sustained. That's correct.
And I guess at some point when you're asking the questions and the judge keeps sustaining the other side's objections, you stop.
No, I understand that. That's certainly true. I'm not sure that 2 questions actually hits that mark. But
Well, actually, there was the third, wasn't there? So nothing has been finalized in Guilford County, objections sustained?
yes, that was there. Defense counsel can clarify whether that is precisely the basis for the argument here, because in his brief he refers to 2 questions, but there was a third objection sustained. You're absolutely right.
It is a little troubling that you have what's been called an evasive answer, Justice for Anthony Johnson, that sort of cries out for follow-up questioning, and defense counsel tries to do just that twice, and both times is told he can't do it or she can't do it. Is it really incumbent upon the defense counsel to keep incurring the judge's wrath by asking questions in that vein?
I don't think it's incumbent upon defense counsel to incur the judge's wrath, but the defendant can't refuse to ask questions and then argue on appeal that the trial court precluded the evidence if the defendant hasn't tried a little harder to elicit that evidence.
So you got to how many objections do you have to get sustained then?
Right. Yeah. I don't have an answer for that. I would like to turn very quickly to the Court of Appeals opinion.
But before you do that, and you may be headed there anyway, it seems that Ms. Malachi was the only eyewitness to the murder of Mr. Johnson.
Yes.
I think I've seen a term used, primary witness. What relevancy does that characterization have with regard to either error or prejudice or both?
This court has found a basis to distinguish Pravat in that line of cases when the witness was not the primary evidence. I think that was the case, Murrell, where the evidence is not as material in the case, then the defendant need not be given so robust a right to cross-examine the witness. That's not really at issue here because the state acknowledges this witness was the eyewitness, the principal witness. So in other cases where it's not the principal witness and the defendant is complaining about a restriction on his right of cross-examination, I think that might be a harder burden for the defendant to show. It's not here. Because,
well, again, does it go to...
It goes to the error. It goes to the error.
Not to the prejudice.
I think that's correct.
But wouldn't it also relate to the question of prejudice? Because if the cross-examination of the only witness to the crime is cut short, that would seem to be more prejudicial to the defendant than if it was not a primary witness.
Absolutely. Absolutely. I think it could go to both. But I think it also impacts the error analysis.
So how do you sort out the error issue from the prejudice issue?
It's not at issue here because the state concedes that this was a principal witness. So we're squarely.
I understand that, but you don't concede. I don't think that any error was prejudicial.
That's correct.
And so my question, maybe inartfully phrased, was how do you sort out the error issue from the prejudice issue in this case?
Right. Yeah. The question of whether the error was prejudicial, we know from McNeil, you have to look at in the context of the entire cross-examination. And it was on the basis of the prejudice question that we got a dissent that allowed us to be here, the state to proceed to this court as a matter of...
So now that we're here, help me understand what I'm supposed to decide.
Yes. So the question of prejudice, you would have to look to the entire cross-examination. As defendant has pointed out on page 16 and 17 of his brief, this was a witness who was thoroughly cross-examination. There were inconsistencies in her testimony. There were inconsistencies in her story to the police. There were inconsistencies in her story to the detectives, the investigators. You would look to how thorough the cross-examination was of this witness aside from the precluded territory. And the state's position here would be that this was a thorough and effective cross-examination even without allowing these additional questions about the pending charges. Very quickly, the court...
I want to make sure I'm clear on what you're conceding and what you're not. You are conceding there was error?
No. What I meant to suggest was we're conceding that this was a principal witness for the state.
Okay.
And so we're squarely in Pravat territory. There's no way to distinguish Pravat, as some other cases have done.
But you still claim that based on Atkins there was no error itself?
Well, that's right. The suggestion in Atkins that Pravat error in particular means that the witness was precluded from talking about pending charges and their effect.
Okay, I understand.
Okay.
Well, the Court of Appeals dissent, which is part of the reason why you're here, says that there was error, but that it was harmless. So do you feel as though there was no error, or do you feel as though there was harmless error in light of what the dissent says?
So this court allowed the state's petition for discretionary review to address also the issue of whether there was error at all. And the state's position is there was no error at all. But if this court were to find error, we would ask you to consider the dissent's position that that error was not prejudicial in light of the extensive other cross-examination of this witness. The Court of Appeals erred in its articulation of the general principle. They said it is well established that pending criminal charges are generally permissible topics for cross-examination. That's just simply wrong. Under Williams and Jones, the general rule is that pending charges are not a proper basis for cross-examination. It's only when the Confrontation Clause issue comes in that this rule is effectuated that the defendant has to be given a right. And then the second problem is that when it looked to the cross-examination that was done here, according to the majority, precluded defendant's counsel from establishing a possible bias because the sustained objections limited the testimony beyond that which the trial court ruled it would allow in voir dire. The violation arises from defendant's inability to question the witness specifically about the bias created by the pending charges, not allowing defense counsel to inquire into her knowledge of plea negotiations for pending charges. The majority seemed to think that there had been an entire preclusion of this evidence about pending charges as there was in Pravat and Davis v. Alaska. And the dissent, although it was based on the question of prejudice, recognized defense counsel was allowed to elicit testimony about specifics of the pending drug charges. The witness testified she hoped to gain justice for the. So looking at what the evidence actually was that was elicited, it's not as restricted as the majority seemed to think that it was. I'd like to reserve the remainder of my time for rebuttal.
Mr. Camargo.
May it please the court, I am Richard Crowthermal. I hail from the Wake County Bar. I represent the appellee defendant, Deval Bowman, in this appeal. I read an article recently on public speaking that said if you want to command your audience's attention a little better, you should gesticulate more with your hands. So I may try that this morning. If that bothers anybody, please let me know and I'll try to tone it down a little bit. As Mr. Hyde pointed out, this is a Confrontation Clause case, and the issue before the court is whether Mr. Bowman was allowed to effectively cross-examine the state's witness, Linda Malachi, concerning her pending drug charges in Guilford County. This murder case with Mr. Bowman took place in Forsyth County. Now, there was record evidence before the court that there had been a conversation between the two district attorneys, the one in Forsyth County and the one in Guilford County, about a possible plea deal for Ms. Malachi. So that brought the issue before the court. That made it allowable. It wasn't precluded simply because Ms. Malachi was facing pending charges in another county. And that comes to us from the case Murrell. So it was an issue that was ripe for the court's attention. The key to this case, and the reason there was error here, and the reason it was prejudicial, is because the difference between the statement "Justice for Anthony Johnson" is much greater than if she had said, "I'm not hoping for anything with respect to my Guilford County charges." Those are two completely different things. And you know that because when defense counsel starts arguing before the jury at the end of the case, he's got to argue the evidence that's before the jury. And if all that she was allowed to say was "Justice for Anthony Johnson," he can't say she's not hoping for anything on her charges or she is hoping for anything on her charges, because that has nothing to do with whether she has expectations about her charges in Guilford. Nothing. It's just, I want justice for my fiance that got brutally murdered. That's a completely different issue on whether she's trying to get out of 19 plus years on charges in Guilford County.
And I should know the answer to this, Mr. Crowthermal, but I don't. Are the jury arguments in the transcript that's been presented for our review?
I'm sorry, Your Honor?
Are the jury arguments that were made in this case in the transcript that we have in this before us?
I believe they are. Let me look at my notes real quick. I don't have that part of my, I believe they are, Your Honor.
Okay.
I don't have that part of my transcript notes, but I believe everything was recorded. Mr. James.
I'm always good for one off-the-wall question, and this is it.
Mr. James, the trial attorney for Mr. Bowman's pretty good. I think he asked for complete recordation. I believe those are all arguments.
I believe they are in the record, and from my quick scan of it, there was no argument made about this issue, about this fodder for impeachment. Was it incumbent upon him to make some argument along the lines that Mr. Hyde was trying to give an example of, even based on the limited questioning that the trial court allowed?
Yes, he should have tried to do something, and I thought he did. His sole case was to attack Ms. Malakai's credibility and say, look, this isn't me who did this. This is probably her who did this, and she's not credible with what she says. But the thing about, if he was allowed to ask her, what do you expect with respect to your pending charges, and get an answer from her about that, either way, either she says, no, I'm not expecting anything on my pending Guilford charges, or she says, yes, I am expecting something on my Guilford charges. Either way, defense counsel can cast that in a negative light before the jury. If she says, I'm not expecting anything on my charges, he argues to the jury, she's lying because she's facing 19 plus years in Guilford County. She has a young son that she wants to continue to care for, so she's not telling you the truth with respect to that. But if she says, yes, I am hoping for some relief on my Guilford County charges, he argues to the jury, you can't believe her testimony because she's doing it to try to get out of these Guilford charges. So that's the key. That's why this was error, because all that was before the jury was this quizzical answer, justice for Anthony Johnson.
Well, Mr. Hyde suggested that Mr. James could have gotten up based on this exchange and argued, in effect, she's got pending charges. They're serious. She get for a long time. I asked her, what she expected to get out of it. She says justice for the victim. Who in the world would believe that? I mean, that's the argument that I think he suggested that could be made. Well, why is that not enough?
Well, this was her fiance. They were supposed to get married. By all accounts, that's a truthful answer. She does want justice for Anthony Johnson, but she probably wants more. She wants to be free, so she doesn't want to go to prison in Guilford. So,
but your contention is that there's not sufficient evidence in this record from which Mr. James's trial counsel could have argued that she's got lots of charges pending in Guilford County. This crime is severe. She can get X amount of time for it. Ladies and gentlemen of the jury, do you really believe that what she wants is justice for the victim, that instead what she's really looking for is some relief on her charges? That argument wouldn't be supported, wouldn't have been permissible?
well, I'm not saying, I mean, it may have been permissible, but whether or not it would have been effective, I don't know. I mean, if he says to the jury, don't believe her, with that justice for Anthony Johnson response, he may hurt his client's chances. The jury may say, well, we believe that she wanted justice for Anthony Johnson.
Well, let's say one more question had been asked and she said, no, I don't have any expectation that I'm going to get any relief on these charges. How does that put the defense counsel in any different position?
Because now he can say, that's not credible testimony, because she said, I'm facing 90 months on the trafficking and meth charge, I'm facing 25 months on the trafficking and marijuana charge. She's looking at least 10 years. If her 4 charges or her 5 charges were ran consecutive, she's looking at 20 years. And he can say, she's got a young child, she has a 4-year-old son that was in the house at the time Mr. Johnson was murdered, and she doesn't want to be taken away from her young son for the next 20 years. She wants to watch him grow up.
And you can't, in your view is you can't make that argument based on the evidence that's in this record?
Mr. James could not make that argument because she was not allowed to answer the question in front of the jury, what do you expect to get on your charges? She did answer that question in the voir dire, out of the presence of the jury, right before the cross-examination, around page 502. She said, I'm not expecting anything on my charges. So I don't know if that confused the trial court, and the trial court said, okay, well, that's not an issue that we need to explore in front of the jury or what, but he should have still been allowed to ask her that question in front of the jury.
So according to the Court of Appeals opinion, which quotes from some testimony that it says was before the jury. The defense attorney asked her whether she had these charges and were they still pending in Guilford County, and she answered yes. And then, what, if anything, have you been offered? And she said, I don't know anything about that. I know nothing
Right, she didn't know anything about an offer. But the question is what do you hope to get based on your charges pending in Guilford County? What do
So
you
there was testimony before the jury that she had charges pending, and that she said that she didn't know anything about any offer.
Right, there were charges pending before that they put before the jury that she had charges pending in Guilford. They talked about how much time she faced, and she said, I don't know anything about a plea offer at this point. But then his question was as well, what are you hoping will happen with respect to those charges based on your testimony here in Mr. Bowman's trial?
So why is it important to have that additional testimony beyond what she did testify to?
So he can cast greater doubt on her credibility. So he can say, and again, like I said before, it doesn't matter what answer she gives. He can cast it in a negative light. She says, I'm not hoping for anything like she did on voir dire before the jury came back. He says, that's not credible because she's facing 10 to 20 years on those charges and she's got a young son she doesn't want to be taken away from. If she says, yeah, I am hoping to get something out of it, which I think is the better answer for her, makes her sound more believable, he can say, well, then you can't trust her testimony because she's hoping to get out of those charges in Guilford County. That's why she's testifying against Mr. Bowman. That's why she's saying what she said. And the other thing that helps the defense in this case is all these other inconsistencies with respect to Ms. Malachi, her different stories to the police, whether or not Mr. Bowman had one or two guns, that changed depending on who she talked to. Whether or not she was pistol whipped before or after the shots were fired in the house, that changed with respect to who she talked to. She didn't want to call the police when she immediately went over to the neighbor's house. She wanted to call friends instead. And then she tried to talk the neighbor into going back to her house where her fiance had just been murdered and do Lord knows what before calling the police. So all these weird things that are going on, this testimony about what she expected on these charges in Guilford would have helped tremendously for Mr. James to then argue to the jury, hey, you really can't trust the
Is your prejudice argument essentially that this would be the straw that broke the camel's back proverbially?
Yes, Your Honor, and that's what I'm getting at with respect to effective cross-examination. The trial court shut the defense down to the point that they couldn't make that one final leap over the hurdle and say, hey, you really can't trust Malachi, the lone eyewitness, if you will. I refer to her more as an ear witness, because what she said was, I turned, ran, and I heard the shot. She didn't actually see the shots fired.
What's your response to the state's position, though, that while we've been isolating primarily on those three questions in that segment of her testimony on cross-examination, that when you look at the entirety of the cross-examination, there is not a violation of privat because of the fact that the defense was properly able to have effective cross-examination to show that she's got pending charges and that may well influence her testimony?
So I went back and looked at Ms. Malachi's testimony, and it begins on page 417 of the transcript, and it ends at about page 625. The cross-examination begins about page 505. Right before page 505, there's a voir dire out of the presence of the jury where they're asking her about these things and what she's going to say. And so it's around page 500, page 502 that she says, I'm not expecting anything on these charges. But when they finally bring the jury back in, the only time they address the pending charges and whether she expected anything out of them is right near the end of the cross-exam, around page 617, 618, up to 620, 622 or so. And that's the only time they talk about those pending charges and whether or not she hopes for anything. If you go back and look at all those other pages, back to 417, there's, except for the voir dire out of the presence of the jury, she doesn't talk about these pending charges or whether or not she expects anything out of them. So that, you really boil it down to those last 5 or 6 pages of her testimony.
So you're saying that this segment of her cross-examination about which we've been talking is indeed the most critical aspect, irrespective of the entirety of her cross-examination here in light of Pravat?
It is the most critical. It is the most important because it kind of wraps up the whole thing as to why she's not credible. He was talking about other things, about this relationship she had with Mr. Sally that the trial court shut down. She had a romantic relationship with him that Anthony Johnson didn't know about. supposedly. There was a question about whether or not she was involved in the drug trade with respect to Mr. Sally, and the trial court kind of shut all that down. And I think I argued that was error too at the Court of Appeals. But what was really important was tying it all together at the very end and saying, okay, you've got these charges pending in Guilford, right? And you're looking at 90 plus 90 plus 25 plus 25, which adds up to about 19 plus years, right? And you understand about plea bargains. I understand plea bargains. Yeah, I get it. And it would really help you if you got a plea bargain in terms of how much prison time you're doing. Yes, I understand that. So what are you hoping to get for your testimony here against Mr. Bowman with respect to those charges? And then that wasn't allowed to come in, other than her saying, I'm hoping to get justice for Anthony Johnson. And then the defense counsel saying, well, I'm talking about your charges. That doesn't really seem to have anything to do with your charges. What about your charges? And then the trial court doesn't let that question get answered. So that's not before the jury what she expects to get with respect to those Guilford County charges where she's facing close to 20 years.
How do you distinguish State v. Atkins?
I'm sorry, Your Honor?
How do you distinguish State v. Atkins that the state's relying upon?
So I talked about that in my brief, I wrote that in Atkins, the defendant was essentially allowed to ask what he wanted to get at, and that's why there wasn't any error there. Whereas here, Mr. Bowman wasn't allowed to ask what he was trying to get at, which was, I'm not talking about the fact that you have charges or how much time you're facing or this justice for Anthony Johnson. I'm talking about what are you hoping comes out of your testimony from this trial?
Well, he wasn't able to get everything in Atkins.
I'm sorry?
He wasn't able to get all of his questions answered in Atkins.
Right. He wasn't able to get all the questions he wanted to get answered, and that's why it wasn't an effective cross-examination, which is what...
No, I mean in Atkins.
I'm sorry?
Sorry. Talk closer to the microphone. In Atkins, he was not able to get all of his questions answered.
Well, in Atkins, he was given an opportunity to ask the witness about promises made in return for the testimony. Here, the defense counsel was not allowed to ask all the questions he needed to ask about what she was expecting with respect to her testimony.
He was allowed. I mean, the earlier question, what if anything have you been offered from the state, is another version of promise.
Well, that's, I guess you could say that.
Well, why would you not say that?
What, if anything, do you hope to gain out of testifying here for this? Well, I mean, what was that object? My take on that first objection, and when I was talking about the two objections, I'm talking about the very two last objections.
But we have to look at all of it, don't we?
Right. But that first objection, he said, has there been a resolution of those charges in Guilford, and there was an objection sustained, and she couldn't have known the answer to that because that's...
It doesn't say resolution. It says, what, if anything, have you been offered?
Well, that's the later question. What, if anything, you've been offered? I don't know of anything I've been offered.
So I don't know.
But that's different from her, whether or not she's going to get something offered, or whether she hopes to get something offered. And that's what he's getting at. He's trying to get at her bias, and that's the whole point of this line of cases with the confrontation clause. Is the witness biased? Is she likely not telling the truth because she's expecting something?
Well, is it your view that you don't have an effective cross-examination unless certain types of questions are allowed, or is your view of what's effective cross-examination the overall inference that potentially can be drawn from the testimony as a whole?
Well, I
hope that's a sufficiently coherent question that you could answer it.
If I'm understanding you correctly, I think it's more the latter. It's a totality of the circumstances issue, and I think you have to look at all of her testimony, going back to page 417 right up to page 625. But ultimately...
All of the testimony that was heard by the jury.
Right, the testimony heard by the jury. But ultimately you want to ask, was the defendant allowed to develop the evidence so that he could make effective arguments to the jury about what he wanted to argue? And so he wants to argue to the jury that Malachi is not credible, and he wasn't given the ability to do that.
And the reason he wasn't, in your view, he was not given that opportunity is because he wasn't able to ask a follow-up question to the "I want justice for Mr. Johnson" answer. What specifically do you expect to get about these charges?
Yes.
That's the difference between your position and the state's?
Yes, Your Honor, because if whatever answer she gives, if it's about the charges, the defense counsel can run with that in closing argument to cast doubts on her credibility.
And your view is that given the answer that was given about I want justice for the victim, that question doesn't permit you to do it because something else might be true?
It doesn't, because it's highly likely it's true. This was her fiance that was brutally murdered. And who wouldn't say, I want justice for my fiance that was brutally murdered? That's just normal human reaction.
Right, and I'm just trying to make sure I understand the difference between the two positions so that I can wrestle with it when we get finished.
Right, so you don't want to stand in front of the jury and say, she's lying about this justice for Anthony Johnson, because the jury may say, oh, we don't think she's lying about that, because that was her fiance that was murdered, and that doesn't help his client. So if he has the ability to say something about what she expected on the charges, that's different. That separates it from the victim. And there was another question earlier when Mr. Hyde was up here about, well, at what point does he have to keep going or not keep going with respect to the objections of the trial court? The defense counsel has to worry about looking good in front of the jury. So he keeps getting into this, and he keeps getting his objections sustained, or his questions sustained. He's not building a good case for his client. He has to, at some point, say, okay, I got to cut my losses. I got to maintain my rapport with this jury. You know, I can't make the judge mad. You know, things like that. All these things defense counsel has to worry about while he's doing all this.
Counsel, in your brief, you ask us to take judicial notice of the fact that 2 months after the trial, the witness did accept a plea deal to reduce charges. And my question is, are we really allowed to consider that, and what issue is it relevant to?
Well, that's a good question, Your Honor. I don't know if you're allowed to consider it substantively for the purposes of this issue. It was the source of a motion for appropriate relief that I filed on behalf of Mr. Johnson in the Court of Appeals, based on a transcript of Ms. Malakai's plea deal in Guilford County. We obtained that, I believe, after the briefs were filed. I'm not sure, I can't remember exactly when I got it now. But the Court of Appeals dismissed it because they said, we're deciding this issue on this Sixth Amendment issue, so we're dismissing Mr. Bowman's motion for appropriate relief. So that's, you know, you may be correct in that you can't consider it at this level because it got dismissed by the Court of Appeals, but it has some information in there about whether or not there really was a plea deal for Ms. Malakai and when it occurred. And I believe the district attorney for Guilford County is talking to the trial court in Guilford County and saying, we heard that there was this murder in Forsyth and that she was a witness and that she was testifying. And at one point, she says to the Guilford County Superior Court judge, I was told that it was either this Mr. Bowman or it was her that committed the murder, but they believed it was Mr. Bowman, and she testified against him, so I want to give her credit for that. And I was going over this transcript with a senior appellate defender at the appellate defender's office, and he heard that and he said, man, that stuff's gold. You don't see stuff like that on appeal with respect to these kind of issues, and that really cast doubt on, you know, whether Malakai knew she had a plea deal or not. So, but given that the Court of Appeals has dismissed the motion for appropriate relief, I don't know that it's appropriate for this court to take judicial notice of it. So,
assuming we agree with you on the error, what about, I'm going to ask you a harmless beyond a reasonable doubt question. What about the state's argument in its brief that the defendant made a recorded statement from jail referencing, quote, the dude I shot, end quote?
So my take on that in my conversations with my client and understanding what was going on, he's having a conversation with his mother or his father who are elderly, and they're having a hard time understanding what he's saying. They're asking him, what are you talking about? What exactly are you saying? What are you talking about? Who are you talking about? And he says, the dude I killed. And what he meant to say was the dude I supposedly killed, not the dude I killed.
I'm sorry, Mr. Crathwell, is this, what you just told us, is that based on the information in the record in this case, or is it based on something that you were told later?
Well, it's not based on any record information. It's based on an inference of what truly happened. He's not admitting to the crime. He's not saying the dude I killed. He's saying that he meant to say the dude I supposedly killed.
And your basis for saying that is just an inference from the record and not something.
Right. I can't point to a transcript page or a record page that says this is what it really means.
Okay, the reason I asked was I thought I heard you say something in your answer to Justice Davis, something about a conversation that you'd had with your client. Did
Well,
I misunderstand you?
I'm sorry, what was that last part?
I said, I thought I heard you say something about a conversation that you had with your client. Did I misunderstand you?
No, that's correct. I said, how do we, what is your take on this? How do we defend against this
So
statement?
this is a question that you asked your client after you began representing?
Yes.
Okay.
And I came on after the trial, after
Right.
the guilty conviction. So if it's not developed in the transcript, that's not before the court.
Right, but the question really isn't the question, what would the jury have thought of that statement?
What would the jury have thought of
I
it?
mean, there is a certain powerful aspect to it, isn't there?
Oh, yes, I agree with you, Your Honor. This case went both ways. I mean, in terms of the evidence, Mr. Bowman made a confession, or not a confession, but a statement to the police after he was apprehended. There was some inconsistencies in there with respect to the evidence they had collected. The question you asked was a recorded phone conversation from a jail conversation on the phone he had with one of his parents. And all of that came in, and I'm not saying it's great evidence. What I'm talking about is whether or not he got a fair trial with respect to how he was allowed to cross-examine Ms. Malachi and cast doubt on the state's evidence and try to convince the jury that, hey, I didn't do this. I know there's some incriminating evidence here, but hey, you got to listen to this part, and you got to understand this, and so forth and so on. That's why we have jury trials.
Well, maybe you could talk to us a little bit about prejudice. If we think that there is error, why does it rise to the level of requiring a new trial, given that there was quite a bit of other evidence?
Well, because I wrote about that in my brief, there was a statement from Pravat where the state, in the appeal in Pravat, the state had argued the error was harmless because there was no evidence of a deal or expectation of a deal, and this court disagreed and noted the following, quote, the effect of the handling of the pending charges on the witness was for the jury to determine. And not letting the jury to do so was error. So that's the prejudice, is let the jury decide if Ms. Malachi is telling the truth about her pending charge, about her hopes for her pending charges. Don't let the trial judge do that and take that away from the jury and then take away an effective defense tool for the defense. So there's that error, and the
Well,
fact,
even if that's error in the face of all of the other evidence of the defendant's guilt from all these other kinds of witnesses, why would that have been so harmless or so prejudicial that it would have required a new trial?
well, I would disagree that the case was as overwhelmingly that the case overwhelmingly pointed to guilt.
I'm not saying it's overwhelming, but there were a lot of witnesses and a lot of exhibits.
Right,
trial.
and if you look back at my Court of Appeals brief, I made several arguments attacking much of that. There was the part about the video evidence from the Bills truck stop and whether or not they were allowed to go in there and correct a witness's testimony as to how far that was off so they could get their timeline done better. I thought that was error. The motion to suppress, I think I argued that with respect to whether or not he invoked his right to counsel. There was a bunch of things going on, and so, I think
Those issues are not before us, though.
right. They're not before you because the Court of Appeals said we're only considering one issue here. We're not considering any other issues. But in terms of the totality of the evidence, I would argue that no, there's not an overwhelming amount of evidence here that points towards guilt, especially given Malachi's position on things and her position within the group. That it was her, Mr. Johnson, Mr. Bowman. There was another gentleman named Washington. They were all part of this drug trafficking group. Malachi was the only one that carried a gun, and it was a 9mm gun. The only bullet pulled out of Anthony Johnson's body was a 9mm bullet. All kinds of things going on here both ways, not just guilt pointing towards Mr. Bowman, but guilt pointing towards Miss Malachi too, in terms of whether or not she might have did this. There was evidence that I don't know that ever got before the jury about this relationship she had with Mr. Sally and whether or not Mr. Johnson knew about it. I think at one point there was an assertion that she was going to go meet Mr. Sally later on that evening after Mr. Johnson fell asleep. And so there's all these things going on that sort of cast doubt on the situation.
To follow up on my learned colleague Justice Hudson's question, if we would in fact find that there was error here, would the fact that it was harmless versus prejudicial be based upon that designation that we discussed earlier, that Ms. Malachi was a primary or a an important witness or whatever designation that she was being given in terms of her role here as the only eyewitness or ear witness here? Would that be some influence?
Yes, I think that plays heavily into it, and that's how the case law is developed, and that's what helped point me towards this error, is to say, hey, when you've got an eyewitness and the state's primary witness, the key witness to the crime, and they're not, and the trial court's not allowing the defense to effectively cross-examine that person, you got a problem, versus some tertiary witness. Like, let's say, he was supposed to meet some guy at the truck stop to pick him up, and let's say he wanted to cast doubt on that witness's testimony, and he brings up his criminal record, and the trial court says, no, I'm not going to let you dive into that. That's not quite as important as Ms. Malachi, because the guy who picked him up at the truck stop has nothing to do with the crime. It's more of the timeline issue. So Malachi, being the eye/ear witness to the crime, that's the one Bowman has to attack. That's the one he has to convince the jury is not telling the truth. So yes, I think that plays a great deal of importance in terms of the prejudice. In sum, I am asking this court to affirm the Court of Appeals decision, the Court of Appeals majority in this case, and find that Mr. Bowman had his constitutional right to the effective cross-examination of the witnesses against him violated, and I'm asking you to affirm the Court of Appeals. Thank you.
Thank you, Mr. Cormato. Mr. Hyde.
I just would like to point out, you did not hear the defendant defend the Court of Appeals general rule that pending charges are generally admissible. That's not the general rule. The general rule is that pending charges are inadmissible, except where the confrontation requires it. That's one reason why this court should not affirm the majority opinion. I did not hear opposing counsel allege that the trial court committed an abuse of discretion. If you look at the Court of Appeals opinion, there doesn't seem to be a very robust awareness that it's an abuse of discretion that's being reviewed here. Justice Ervin, as you pointed out, defense counsel asked the question. This was before any objection. What, if anything, have you been offered from the state at this point regarding those pending charges? This was before the jury, and Lakenda Malachi said, I don't know nothing about that. All of the arguments that opposing counsel is suggesting defense counsel could have been made on the basis of the evidence that was elicited. All of those arguments could have been made on the basis of this evidence. And it's for that reason that the trial court did not abuse its discretion in sustaining those objections, and the state would respectfully ask this court to overturn the decision of the Court of Appeals. Thank you.
Thank you to both counsel. Madam Clerk.
All right. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning in Durham, North Carolina. God save the state and this honorable court.